Hi, Lisa here. I wanted to take a minute or two to talk to you about non-compete agreements. It comes up a lot in my practice. It comes up a lot with business owners. So I thought it would be useful information to share with you. So, what is a non-compete agreement? It's a tool that you can use to protect your business from unfair competition by someone who has had access to your private, unique, or proprietary information that's vital to the operation of your business. So, who typically signs a non-compete? Commonly, it's going to be your employees, partners of a business, a seller of a business, or a potential buyer of a business who will have access to information to make the decision about whether or not to buy the business. So, are non-competes enforceable? Well, that depends. Very lawyerly answer there. But the general rule of thumb for an enforceable non-compete agreement is that it needs to be limited in both time and geographic scope, only to the greatest extent necessary while still protecting the business's interest. What we really don't want to happen is that we're taking productive members out of the workforce just in the interest of preserving a single business. So, because of that, state laws are trending now against non-competes. States like California, North Dakota, the District of Columbia, Oklahoma all consider non-competes to be either entirely or largely unenforceable as they're seen as being against public policy. Other states such as Maine, Maryland, New Hampshire, Rhode Island, and Washington State have banned non-competes for specific groups of people, specifically low-wage workers. Oregon, Nevada, and Illinois have also passed legislation that is curtailing non-compete agreements. In Massachusetts, specifically, there is a provision in our law addressing non-competes referred to as the garden leave provision. For non-compete agreement with an employee to be enforceable, it has to state that the employee will be compensated for the period during which they cannot compete. Typically, it would be their salary, or it has to be some other consideration of value. But that last bit has not been clearly defined by the law. It also has not been tested in court, so no one really knows what that means and what you would need to do to make it an enforceable agreement. So, how do you protect your business in light of the difficulties that you would face in implementing a non-compete agreement? You use solid non-disclosure and non-solicitation agreements in its place. Those are enforceable everywhere. They protect the business's competitive interests without keeping someone out of the workforce by preventing the sharing of that confidential information or using it for a competitive advantage, and also preventing the direct solicitation of employees, vendors, and customers. So, to ensure that your business is protected, you need to work with local counsel who is aware of the different non-compete laws or law that would apply in your situation and draft the appropriate agreements for you. So, hopefully, this is a little helpful about non-competes, why they're so confusing and complicated, and you can work with counsel to find a way to protect your interests the right way.